Hey, what's going on, fam? So this is another video. This is about the Byron Allen case. And obviously, as you guys know, Byron Allen lost his Supreme Court case about a month ago. And I've obviously been talking about Byron Allen a lot on my channel. I've had a few concerns and questions about the movement, the ADOS movement / organization, and their support of Byron Allen. And obviously, my issues with the ADOS movement overall started to cause me to question and openly question. At first, I was trying to stay on code, but once they started to go off code, and at least off code as far as I look at things, um, I started to question a lot of things about that movement. And one of the things that I was questioning was the Byron Allen support. And two of my chief concerns with the Byron Allen support was A, the fact that even though Antonio Moore / Tone Talks consistently, and even Yvette Carnell to some degree, as consistently brags, and that I can't think of a better word to describe it other than bragging, that the ADOS movement is the chief reason why Byron Allen got any support in his case against Comcast. We were the only ones there. It was only us. We was the reason why. We put pressure on the NAACP and the National Urban League. We raised the awareness. We sounded the alarm. It was us. It was us. It was us. It was us on the Supreme Court steps. Nobody else. It was us. It was us. It was us. Constant taking basically credit for almost all the publicity and support that Byron Allen got, or positive publicity, and Byron Allen got for his Supreme Court case. Yet, I have yet to ever see, and somebody, if you have video, not him at the ADOS conference, because that's private, that's behind closed doors. Nobody saw that except people who were at the ADOS conference and people who watched it on live stream. So don't tell me that Byron Allen did a thank you video at the ADOS conference. Send me one video of Byron Allen in any kind of public news media acknowledging or thanking the ADOS movement. As a matter of fact, I'll lower the standard. I don't even need a video. Send me an article from a major news outlet acknowledging the ADOS movement. And don't tell me it's not a movement, because Tone said it was a movement, especially when he tried to G-check the leader of, or the founder of the FBA term. He said ADOS is a lineage, but it's also a movement. He said that in his G-check video when he jumped on YouTube, whining about a comment that could be interpreted as supporting Trump. But to me, wasn't supporting Trump. But I digress, because this video isn't about that. But I'm just saying, why hasn't Byron Allen acknowledged the ADOS movement? Especially when one of the founders of the ADOS movement holds someone like LeBron James, who was fighting against a racist ruling, racist NCAA rule. The requirement for LeBron James to get our support was that he support reparations in ADOS. Yet Byron Allen doesn't even have to acknowledge ADOS or reparations. But we owe him our support. My other question was, because I know the answer to why we owe Byron Allen our support, even though he hasn't acknowledged the ADOS movement, even though they're supposedly the sole responsible organization for his publicity and his success and support. But my other question was, how is this law that was crafted in 1866, this huge borderline end-all be-all protection of black rights, when we had to have a civil rights law of 1964, basically 100 years later, 98 years to be exact, but basically, if you round it up, 100 years later? What was going on? What was that 1866 law doing for 100 years to protect our rights? Because as far as I know, especially when you compare it to the level of rights that black people have in 2020. We had no rights in 1920. So where was the 1866 civil rights law then, when there was Jim Crow and white only signs? The 1866 law is supposed to guarantee that black citizens have the right to make and enforce contracts as white citizens, the same rights enjoyed by white citizens. Yet this was a time when we had whites only signs. Do you really think white supremacists were honoring contracts when they were able to put up whites only signs and rape and murder without conviction, which were also against the law at those times? Do you really think they were respecting the 1866 civil rights law when they weren't even respecting murder laws? You think they were respecting laws about contracts, about black rights to contracts, when they weren't even respecting laws about black rights to life? So it didn't make sense to me. It was like, where was the 1866 law for 100 years? Why do we have to have a civil rights movement basically 100 years after that law was passed, if it's such the end-all, be-all, and foundation of black rights? And nobody could answer that question for me. And I've had to do research, obviously, for this video, but even as I've done research, I still haven't been able to find an answer to that question as to how this law is the end-all, be-all of black rights. I still don't have an answer to that question. What I do have is I guess, a semi-answer, but not a satisfactory one. The semi-answer I have from doing my research, and let me make sure to make clear, I never got an answer from anyone in the ADOS movement. Never got a satisfactory answer. And I still haven't gotten a satisfactory answer. However, I've gotten a semi-answer, but it's not satisfactory, from my research into this case. And from my research into this case, the answer that I've gotten is that the reason why people are saying that this is the end-all, be-all of black rights, or not even the end-all, be-all, let me stop saying that, but that this is very significant to black rights, extremely significant to black rights. The reason why I'm getting that, excuse that I'm getting, is that because of the fact that the Supreme Court ruled a certain way, that is what is damaging to black rights. What I have not gotten was that this law explicitly, meaning that it directly has language in it that specifies that it holds itself to the motivating factor standard, which I'm going to get into in a moment, motivating factor versus but for. I have not seen any proof that this law explicitly holds itself to the motivating factor standard. Because what's up for dispute, and you're going to hear this as I read some articles, because I'm going to read several articles, actually about 10, so be prepared, fam, for this to be a much longer video than my normal videos. It's probably going to be an hour, possibly longer than an hour, so make sure that, like, maybe hour and a half, hour and 45 minutes. So make sure that you have some time, fam, when you sit down and you listen to this video. I would say at least 2 hours, but maybe an hour. We'll see how long the video is, obviously. My apologies for the cough, but we'll see how long the video is, obviously, once it's done. But be prepared for a longer video. I'm just saying that as I'm making this. But anyway, fam, the crux of the Byron Allen case is about motivating factor standard versus but for standard. Now, the people who have taken Byron Allen's side, and I just mentioned to y'all I'm going to read some articles, and most of these articles are going to be from people who have taken the Byron Allen side of the story, because there's two sides to this story. The Byron Allen side to this story is that the law will not change. I mean, the law will be changed if the Supreme Court rules against Byron Allen, which they did, obviously, and it will significantly reduce the rights that we had before. Whereas Comcast side of the story is that Byron Allen is trying to misuse a racist law for his own personal gain, which I suspected, and that's part of the reason why I was asking questions in my previous videos about the Byron Allen case. But Comcast's side of the story is that Byron Allen is misusing a civil rights law for his own personal gain, and that all this Comcast is fighting for is for the law to be interpreted correctly so that people like Byron Allen are not able to abuse it. And you'll see what I'm talking about as I start to read the articles, because the articles will explain what I'm talking about. But I'll also, interject as I'm reading the articles and explain myself. But you'll see what I'm talking about as far as what Comcast means by Byron Allen is trying to abuse the law and use it for his own personal gain. And what's up for dispute at the Supreme Court is whether or not the 1866 law that Byron Allen is using to make his case, whether or not that law should be held by what's called a motivating factor standard as opposed to a but-for standard, which is what Comcast wants. Now, the motivating factor standard, the motivating factor versus but-for works like this. I'm going to give you an example. So let's say I'm trying to apply for an apartment in an apartment complex. And the minimum credit score at this apartment complex is 630. That's the minimum. Obviously, they would prefer for you to have a higher one, but the bare minimum to get an apartment in this hypothetical apartment complex is 630. I walk in there and I have a credit score of, for example, 629. Now, if I were a white person, because I'm so close to the minimum, the leasing office, the people that work there would feel empathy for me and still approve my application, even though technically I'm not even meeting the minimum to get an apartment there. So technically they could reject me, but because I'm white, they chose to overlook it because I was so close. But because I'm black, they say, you know what, sir, our credit score is 630, and that's the minimum. So you're not even at the minimum. I know it's close, but hey, I can't approve your application. Now, if it was by the motivating factor standard, and if I wanted to say, hey, I want to prove that I know that if I was white, you would have accepted my application. Let's even say hypothetically the leasing office said something racist to me in the office while they told me that they were denying my application because I'm black. Because I have a low credit score. The motivating factor standard says I only have to prove that race was a part of the reason. So even if you have other legitimate reasons to deny my application, like my credit being too low, as long as I can prove that race was part of the reason, even if it wasn't the only reason why you denied my application, I have a legitimate case against you, and I could possibly sue you for money or force you to let me in an apartment, or a combination of both. By the but-for standard, even if I could prove that race was part of the reason, if I can't prove that it was the only reason, then my case gets dismissed and I lose. So that's basically it. That's the summed up version of the motivating factor versus the but-for standard. Now, what's not being told to you, especially as I read these articles that are in favor of the Byron Allen side of things, which is that this law is being changed or will be changed if the Supreme Court rules in a certain way, whereas Comcast is saying that the law is not being changed. My question is, and that was my concern back when I was making other videos, was it does kind of seem like the law is not really being changed, because this law was not protecting us in the first place. So I'm not seeing how this law allegedly being changed is going to hurt us so much. And I'm not sure if it's being changed or if anything will happen to us as a result of it, because of the fact that it wasn't protecting us for over 100 years. And it's technically still not protecting us. Me saying 100 years is being nice. It technically still is not protecting us to this day. in 2020. That's why we have Darren Wilson's and George Zimmerman's running free and not in prison. That law is not the foundation to any real rights that we have, because it's not protecting us. When the white supremacists decide to override the law, they're going to override the law. And this is why I emphasize an understanding of white supremacy and not just the data. Because you can have all the data you want. White supremacy is going to decide what they want to do anyway, which is why you have to focus on toppling white supremacy. And your reason for wanting reparations is to weaken and cripple and topple white supremacy. Not because you got the data and the birthright. It's not about that, even though it is partly about that. That's our reason for getting reparations. That's not the overall issue. The overall issue is the system of white supremacy and anti-black racism. But anyway, fam, again, my question was, how really impactful is this law? And as I read these articles that are mostly in favor or are taking the side that this law is being changed and this is damaging black rights, I want y'all to understand that the Supreme Court is about interpretation. Meaning that, and the law is about interpretation. That's why the Supreme Court exists, because a large majority of law in America is up for interpretation. Meaning that it's like almost like the Bible. That's why we have 100 different denominations in Christianity, because there's so many different verses in the Bible that can be interpreted different ways. And that's why we have a million different denominations. It's almost the same thing with law. Even though there's not quote-unquote denominations in American law, even though there kind of are. Obviously, there's different types of law. But there's not like religious denominations in law. There is still so much of law that is up for interpretation, to the point that that's why you even have a Supreme Court. Because so much of law is up for interpretation. So I want to what I'm saying that is because these articles, and if you read, and I'm going to provide them in the links in the description box. So obviously, like I always do, for full transparency, everyone can go and read the articles that I reference themselves. But what you're going to see if you read these articles, people are talking about as if it's a certified fact that the law was changed, almost as if the motivating factor standard was in the 1866 law, or that the 1866 law was explicitly stating that it was held to a motivating factor standard. And that's not exactly true. All it says is that black citizens enjoy the right to make and enforce contracts the same as white citizens. To me, that does not say whether it's necessarily a explicitly but for or motivating factor standard. And my assumption is, the common sense assumption is, that's why it was even up for a dispute and willing to be heard at the Supreme Court. Because neither side could definitively say, without the arguments first being made. No one could just read it. You have to make the argument first. No one could just definitively look at the law and say, hey, this is motivating factor. The reason why people are talking as if the law is explicitly motivating factor is because it does not say explicitly but for in it. And a lot of laws that are held to the but for standard do say but for in them. But the 1866 law apparently does not, because that's the justification that I've read as to why people are saying that the law is a motivating factor standard law, the 1866 law. Is because of the fact that it does not say but for, therefore it must be motivating factor. But that's an issue of interpretation. I'm sorry, but it is. That's why the Supreme Court has to hear it. Many laws in the American judicial system are up for interpretation. Now, when you understand white supremacy, you understand that that's kind of how just white supremacy works. That's also known as the I'm white and I say so law. But technically, in legalese, this law did not go one way or the other. So I want y'all to keep that in mind, because these articles are on the side of Byron Allen. So they talk like the law was officially changed. But technically, by the books, the Supreme Court is not able to change a law. They can only interpret law. The most they can do to change a law is either strike it down completely or strike down parts of it because they rule it unconstitutional. That's the most a Supreme Court can do, technically by the books. Now, let me say this. For people who actually pay attention to Supreme Court stuff, people have opinions that the Supreme Court does change the law based on how they interpret the law. But officially, technically, by the books, it is illegal for the Supreme Court to change laws. They can't change laws. They either uphold a law or they strike it down. They either confirm a standard or they deny a standard. They interpret the law. They are not allowed to make laws. They are not allowed to modify laws other than removing sections of a law that are declared to be unconstitutional, or completely declaring an entire law itself unconstitutional. That's the most they can do to, quote unquote, change a law. But they're not writing policy. They're not adding amendments. They can't do that. So I just want to make that clear, fam. So when you read these articles and you hear people talk about the ruling as if, oh, this has changed black rights. Officially, technically by the book, that's not true. Now, depending on how you look at the situation and depending on how you understand white supremacy, yes, I can understand how you would say that they, quote unquote, changed the law. But if we're going by the book definition of what the Supreme Court does, it is impossible for them to change the law. All they did was interpret the law. You just don't agree with what they interpreted. That's the official explanation. Now, I know, fam, that was a long preview, but all this, and I'm not even a legalese expert or a Supreme Court expert or anything like that. I'm not a lawyer, but as I was doing this research, this case can be very confusing unless you have a thorough explanation and you understand what you're hearing before I actually just start to read the articles. Because if I just start to read the articles, it's not really going to make the point as opposed to if I explain like I just did. So my apologies. I know that was an extremely lengthy explanation. That could have been a video in and of itself. But as I said, fam, or one of my normal length videos in and of itself. But as I said, fam, prepare for this to be a much longer video than my normal videos. So anyway, fam, without much further ado, I'm going to read these articles. I just want to say one last thing before I start to read the articles. Because I have multiple articles, and this video is already going to be longer than my normal videos, I'm not going to read the whole article of every article. There's like 2 articles that I want to read pretty much the whole article, but other articles I'm going to read parts of it. As I said, I'm always transparent. So if anyone wants to think I'm hiding something, twisting something, covering something up, whatever, you can always go to the description box and you'll see all the articles. It's going to be about 10 different articles. All the articles in the description box. So you can read the entire articles for yourself. And any article that I didn't read the entire article of, you can see what I left out and see if I was hiding something or snaking by something or whatever you want to possibly accuse me of. So that's number 1. Number 2, almost every article I'm going to read is from the perspective of the Byron Allen side of things, which is why I put out my explanation of the motivating factor standard and what the Supreme Court can and can't do before I started to read these articles. But one of the articles is going to be on the side of Comcast because there's 2 sides to every story. As I said already, there's 2 sides to every story. So one article is going to be on the side of Comcast, and that article that's on the side of Comcast, it has some interesting information that none of the articles that were taking the side of Byron Allen revealed. So I'm going to read parts of the article. The article that's on the side of Comcast, I'm probably going to read that whole article because Obviously, all the other articles are on the side of Byron Allen. So just to give a little bit more balance, that's probably going to be one of the few articles I read in its entirety. But just know that, fam. So no, I'm not reading the entire articles, but you can always double check for yourself after this video is done. And most of the articles are seeing things from the side of Byron Allen. Only one article is seeing things from the side of Comcast. So anyway, without further ado, fam, let's go ahead and read these articles. So the first article I want to read is from a website called Deadline, and the title of the article is Supreme Court in unanimous decision says Byron Allen must meet higher threshold to continue racial bias case against Comcast. The Supreme Court sided with Comcast over Byron Allen in his racial discrimination case against the cable giant, ruling that in order for his lawsuit to survive, he bears the burden of showing racial discrimination was the but-for cause in the cable giant's refusal to carry his entertainment channels. The justices, in a unanimous decision, ruled that to prevail, a plaintiff must initially plead and ultimately prove that but for race, it would not have suffered the loss of a legally protected right, according to the opinion. And then there's a link to the actual opinion, and it says read it here. And fam, I suggest when y'all have the time, take the time, click the link to the actual opinion, the Supreme Court Justice's opinion in this Deadline article. It'll be the first link I put in the description box. So you can read the opinion for yourself. And even there, when you read the Supreme Court opinion, you will see all the language about interpretation in that Supreme Court opinion. But the justices aren't just interpreting based off their personal opinions. They use other cases and other laws to back their interpretation. So when you read that opinion, you'll see where they're using other discrimination cases and even non-discrimination cases that are held to the but-for standard. And that's what they use to justify their decision in Byron Allen's case. So anyway, let's continue with the article. And again, the justices in a unanimous decision ruled that to prevail, a plaintiff must initially plead and ultimately prove that but for race, it would not have suffered the loss of a legally protected right. And I know I kind of reread that paragraph, but I'm going to be interjecting, obviously, fam, as I read these articles or read parts of these articles and, providing extra context and explanation. So sometimes I may go back and reread a part that I left off at just so that nobody gets lost and forgets, where I was at in the article when I go back to the article. Because I want to be jumping back and forth like I'm doing right now between reading the article and kind of just dialoguing and not reading the article. But anyway, back to the article. The decision means that Allen's lawsuit will go back to the lower court where he can again try to prove his case, but he will have a much greater threshold to meet for the case to survive. At issue was whether Byron Allen's $20 billion lawsuit should have survived beyond the pleading stage by merely proving that in Comcast's decision to deny carriage of his entertainment studio's channels, his race was a motivating factor, or whether it was the sole cause, also known as but-for in legalese. The ruling was viewed, because remember, interpretation, fam, remember, I want y'all to keep that in mind the whole video. That's why I'm using the screen cap I'm using. The ruling was viewed as having a potentially, these are words that indicate opinion, fam. The ruling was viewed as having a potentially significant impact on future racial discrimination cases. The Ninth Circuit ruled in favor of Allen last year, but in oral argument, some of the justices found fault with the lower court's reasoning. Again, the Ninth Circuit ruled in favor of Allen last year, but in oral argument, some of the justices found fault with the lower court's reasoning. Fam, what is reasoning? Reasoning is logic. It's thinking through things. They did not say they found fault with the Supreme Court's ability to understand. I mean, well, they kind of did say that, but the Supreme Court didn't say they found issue with the law itself. They said they found issue with the court's ruling. So the Supreme Court didn't say, you know what, the Ninth Circuit, they followed the law, but we decide to change it. We don't like that law. We don't feel it's fair, so we're going to change it. That's not what happened. They said they agreed. The Ninth Circuit Court, which was a court lower than the Supreme Court, they disagreed with the Ninth Circuit Court's interpretation, aka reasoning, of the law. So I just want to emphasize these words are telling you that this is more opinion based than facts based. So when you hear me read articles that claim that the law was just changed and that's the official story, I'm still not sure if that's the official story. But if it is, what does it really matter anyway when this law wasn't protecting us in 1920? We were still dealing with white supremacy. And none of our rights were being protected. Not the right to make and enforce contracts or any other rights, especially in the 1920s. So anyway, fam. But in oral arguments, justice found fault with the lower court's reasoning. The justices showed clear skepticism of issuing a definitive ruling that established a lower threshold in racial discrimination cases when a case is first filed, and a higher one if it reaches a trial. Justice Neil Gorsuch, who delivered the opinion for the court, wrote, "Here, a plaintiff bears the burden of showing race was a but-for cause of his injury. And while the materials the plaintiff can rely on to show causation may change as a lawsuit progresses from filing to judgment, the burden itself remains constant." The opinion was posted online only, as justices have postponed in-person proceedings out of concerns over the spread of the coronavirus. At the oral arguments, Erwin Chemerinsky, remember Tone in his night before the Supreme Court video, said, "We got Chemerinsky. He cost millions. You don't know nothing about that. I called B. I got B on the line. Chemerinsky cost millions." He was talking like Chemerinsky was this big badass lawyer, and all of us peons, we don't know nothing about what it costs to get the amount of money it takes to get a Chemerinsky. Yet Chemerinsky, the big bad lawyer who cost millions, took a unanimous L. Just to explain to y'all, the Supreme Court does not have to have, there's 9 Supreme Court justices. The Supreme Court does not have to vote 9-0 for them to make a decision. It can be 6-3. It can be 5-4. As long as a majority of the Supreme Court takes one side or the other of a case, that's the decision. Pretty much. I don't want to get into too much complicated Supreme Court stuff, but for the most part, and again, for the most part, because I know there's going to be somebody who does want to deeply research the Supreme Court and try to nitpick me. So for the most part, when a Supreme Court makes a decision, whether it's unanimous or not, it's final. Yet you took a unanimous L, this big badass lawyer. And again, this is not really to shit on Chemerinsky. I don't know the man. Maybe he's a good-hearted man. Maybe that's why he took the case in the first place. But I'm talking about how Antonio Moore bragged and was arrogant about Chemerinsky and bragging about how much money he cost. And then this is the man who turns around and takes an L. But we got Chemerinsky. But okay. But anyway, back to the article. At the oral arguments, Erwin Chemerinsky, who was arguing for Allen, acknowledged that he would eventually have to show that race was the sole cause for Comcast rejection. Let me reread that. At the oral arguments, Erwin Chemerinsky, who was arguing for Allen, acknowledged that he would eventually have to show that race was the sole cause for Comcast rejection. So Chemerinsky, Byron Allen's lawyer, admitted that he would have to meet the but-for standard eventually. His argument was that he should only have to meet the motivating factor standard at first. So I want y'all to also keep that in mind, because everyone who's talking in favor of Byron Allen is telling you that the motivating factor standard was the law in the story. But even Byron Allen was the standard that the 1866 law was held to, and what all of our civil rights laws apparently should be held to, is the motivating factor standard. And once the Supreme Court changes that, we lose all our rights, because the motivating factor standard is the protection that we need to prove discrimination. Yet, Byron Allen's lawyer admitted that the motivating factor standard is only the law for a part of the process, and that's in their opinion, in their interpretation. The Supreme Court justices, and honestly, when you look at it from the side of Supreme Court justices, let's just be logical. Let's be fair, family. Let's not be emotionally biased towards Byron Allen. Let's be fair. Do you not see how someone, especially in a system of white supremacy, could say, I don't know about this. Oh, I only got to meet one standard at first, but then I got to meet another standard at the end. Like, that's weird that you're going to have two different standards for the same law. You're going to have a motivating factor standard for part of it, and then a but-for standard for the other part. Now, to be honest, on the side of black people, I do get the argument that's being made, because the argument that's being made from the black people side of things is that, hey, it's hard to prove but-for at first. So we should at least get motivating factor until we can subpoena the company and do depositions and get documents and all of this stuff from the company. I should only have to prove motivating factor until I can get enough proof to prove but-for. So I get that argument, but I also get on the other side how someone could say, this is weird, this is not right, that you're asking for two different legal standards. That's why I read earlier, even though I just kept reading through it, is Justice Neil Gorsuch, who delivered the opinion for the court. Here, a plaintiff bears the burden of showing that race was a but-for cause of his injury, and while the materials the plaintiff can rely on to show causation may change as a lawsuit progresses from filing to judgment, the burden itself remains constant. And even earlier than that, the justices showed a clear skepticism of issuing a definitive ruling that established a lower threshold in racial discrimination cases when a case is first filed, and a higher one if it reaches trial. So basically, when you make your complaint, you only have to make motivating factor standards, but once you get to trial, you still have to meet but-for standard. That's Byron Allen's argument, which is weird, because everybody who's on his side is telling us that the law should just be motivating factor, end of story. But Byron Allen's lawyer is over here admitting, no, it is but-for, but just not yet. That's kind of weird. Do you see how he's kind of setting himself up for an L? And maybe he had no choice, and you'll see more. Maybe a little bit of what I'm talking. I'm talking about Byron Allen's lawyer. Maybe he had no choice but to set himself up for an L, because of the fact that Byron Allen even chose to bring this lawsuit in the first place, which it's questionable that he should have even brought this in the first place. And you'll see what I mean as I read some other articles. But anyway, again, Erwin Chemerinsky, who was arguing for Allen, acknowledged that he would eventually have to show that race was the sole cause for Comcast's rejection. But he argued that it would be an insurmountable burden to meet if plaintiffs have to prove that at the outset of the case, as they would not have the benefit of conducting depositions and discovery. So that's all I want to read from that article, fam. Again, that's the Deadline article. It'll be the first article in the description box. So, fam, the next article I want to read is from Variety. And this article it's a website / news organization called Variety. And it's titled, Supreme Court Rules in Favor of Byron Allen Discrimination Case. And it's authored by the article is written by a young lady named Cynthia Littleton, which sounds like a black name, but to be honest, I'm not sure if she's black or white. But anyway, this is one of the articles that more so view things from the side of the Byron Allen case, because at the end of the day, they still say the same thing, that this law is a significant change to black rights. All right, and again, I'm not reading the whole articles, except for a few, so I'm starting in the middle of this article, this Variety article. Filed in 2015, Allen's suit was dismissed 3 times at the filing stage by lower courts. Let me reemphasize that. Filed in 2015, Allen's suit was dismissed 3 times at the filing stage by lower courts, meaning his case was already dismissed as suspected to be frivolous and baseless from jump 3 times. In 2018, the Ninth Circuit Court of Appeal argued that those courts had erred and that the motivating factor standard was enough for the case to move into the discovery phase. So basically, Byron Allen kept appealing and appealing and appealing until he got a ruling in his favor. But once Byron Allen kept appealing, Comcast decided to appeal and appealed it up to the Supreme Court. And they were only one level below the Supreme Court when Comcast decided to appeal. So Comcast appealed that decision to the nation's high court, which heard oral arguments on November 13th, 2019. That argument revolved only around the nature of the test to be applied in the final determination of whether Comcast actions violated a civil rights law enacted in 1866 to ensure that newly freed slaves would have the same right to make and enforce contracts as white citizens. The narrow scope of the Supreme Court argument turned on the causation standard and the impact of that burden of proof in the case. Allen's legal team, led by UC Berkeley School of Law Dean Erwin Chemerinsky, argued that the suit should proceed with the motivating factor standard, which would have the effect of forcing Comcast to prove that race wasn't the sole factor in his decision, rather than keeping the burden on Allen to prove that race was the only factor. Allen's team argued that the motivating factor standard was spelled out in other civil rights laws. Again, not the 1866 law. Allen's team argued that the motivating factor standard was spelled out in other civil rights laws, not this law. So again, he's looking at other laws and saying, well, this other law has the motivating factor. Why not 1866? That's interpretation. There's no explicit definition in the 1866 law that says that it's held to either standard. It doesn't say that it's held to the but-for standard or the motivating factor standard. That's why Allen's team argued that the motivating factor standard was spelled out in other. They didn't say it's spelled out explicitly in the 1866 law. They said it was spelled out in other laws that had to come after the 1866 law because it was too damn weak. And if anything, Byron Allen, and you'll see what I'm talking about when I read the other article, Byron Allen possibly caused the 1866 law to now have to be held by the but-for standard when there was still, prior to that, a chance that it could be held by the motivating factor standard. Because different courts can interpret the law different ways. So depending on where you live and what court you go to, you could only have to meet the motivating factor standard. But now that the Supreme Court has ruled on it, no matter where you live or what court you go to, you technically have to meet the but-for standard because of the interpretation. So, if anything, Byron Allen possibly jeopardized and harmed black rights by causing a ruling that made but-for definitive when it wasn't definitive before. Allen's team argued that the motivating factor standard was spelled out in other civil rights laws over the years that aimed to attack the same problems, but the court did not agree in the opinion penned by Justice Neil Gorsuch. To accept Entertainment Studios, this Byron Allen, that's what he owns, Entertainment Studios, and this is the judge talking. To accept Entertainment Studios' invitation to consult, tinker with, and then engraft a test from a modern statute onto an old one would thus require a more than a little judicial adventurism and thus look a good deal more like amending a law than interpreting one. Let me reread that. To accept Entertainment Studios' invitation to consult, tinker with, and then engraft a test from a modern statute, a statute is a law, onto an old one would thus require more than a little judicial adventurism and look a good deal more like amending a law than interpreting one. Why does Justice Neil Gorsuch say it looks more like amending a law rather than interpreting one? Oh, because he's not allowed to amend the law. He's only allowed to interpret one. So all these articles and the ADOS movement telling you that the law was changed, that's not technically true because the Supreme Court is not able to change a law. It's only allowed to interpret it. And if you want to tell me that they changed the law and that they defied the law, again, that plays into why I keep emphasizing white supremacy. You can't sit up here and babble about the data without speaking in a context of white supremacy. And if you really let me not go off on a side tangent because I was about to. back to the article. So, anyway, uh, that's it for that article. That's all I wanted to read from that article. Let's go ahead and move on to um, another article. One moment here, fam. And I just want to, I'm actually skimming this article to see if there's anything else that I want to read. Okay, yeah, actually, so there's one more part from this article um, that I want to read. So I'm not done. My bad. I said I was going to move on to another article, but I'm not yet. I still have a little bit more to read from this article. So I'm skipping over a couple paragraphs, but I want to read two more paragraphs before I move on from this Variety article. As indicated during the oral arguments, the justices were skeptical of the correct standard to be applied as offered by Allen's team. As indicated during the oral arguments, the justices were skeptical of the interpretation of the correct standard to be applied as offered by Allen's team. During arguments, the justices pressed Chemerinsky to acknowledge that to prevail in the end, the case would have to prove the but-for standard. At times, Entertainment Studios seems to argue that a plaintiff only bears the burden of showing that race was a motivating factor in the defendant's challenging decision, not a but-for cause of its a motivating factor in the defendant's challenge decision, not a but-for cause of its injury. At others, ESN, this is Entertainment Studios Network, which is Byron Allen. At others, ESN appears to concede that a plaintiff does have to prove but-for causation at trial, but contends that the rules should be different at the pleading stage. According to this version of ESN's argument, a plaintiff should be able to overcome at least a motion to dismiss if it can allege facts plausibly showing that race was a motivating factor in the defendant's decision. ESN admits this arrangement would allow some claims to proceed past the pleading stage that are destined to fail as a matter of law. Still, the company insists that is what the statute demands. Let me reread that last part. ESN admits this arrangement would allow some claims to proceed past the pleading stage that are destined to fail as a matter of law, which is basically means that Byron Allen is admitting, or not Byron Allen, but Byron Allen's lawyers and his team, Chemerinsky, is admitting that they're basically double standard of only meeting motivating factor at first, but then still having to meet but for later, will allow some cases that have no business being brought, being allowed to continue a lot longer than they should. Because as much as I would like for black people to have rights and even have extra rights that other people don't have because of all the racism we've been through, as much as I would love that, do you really think white supremacists are going to go for a world where black people are allowed to falsely claim racism in order to get whatever they want from a white supremacist and from white society? Do you really think they want to live in a world where that's legal? Where black people can actually bring false claims of racism? They don't want to listen when black people bring real cases of racism, let alone false cases of racism. So if you understood white supremacy, if you had enough understanding of white supremacy, instead of running around with a white wife, if you had enough understanding of white supremacy to understand that white supremacists don't even want to acknowledge when a black person is actually being discriminated against, why would you bring a case that puts in jeopardy the interpretation of a law and would allow, or why would you want to bring a case to the Supreme Court that allows black people to lie and think that that's actually going to go over well with the Supreme Court in a system of white supremacy that permits black people to lie? So again, that's what this is saying. ESN admits this arrangement would allow some claims to proceed past the pleading stage that are destined to fail as a matter of law. But then again, fam, as far as why you would allow cases that potentially have no basis to proceed, maybe the reason why you would want that to be allowed is because that's what Byron Allen is doing. He's bringing a case that has no basis to proceed. Possibly. I'm not saying that he is for sure, but he possibly is bringing a case that has no business to proceed and be brought forward. And you'll see what I'm talking about, especially when I read the article from Comcast side of things. But fam, let's just think of one quick thing or one quick side note before I continue. Remember, in my example about the apartment complex, Byron Allen's lawyer is acknowledging that even if I could prove that it was only a part of the reason when I was bringing my lawsuit against the apartment complex, I would still eventually have to prove that it was the only reason. So even if I had excuses or enough to show that it was part of the reason, unless I can turn that part of the reason into the only reason, meaning unless I can prove that the 629 credit score had absolutely nothing to do with me being denied, which would almost mean that I would have to prove that the 629, that the 630 is not their real minimum credit score. So how much is it really protecting us if we still eventually have to meet the but-for standard? Because in that apartment complex example, if their standard is actually 630, it is extremely hard for me to prove but-for at any point. So is this really about protecting our rights if you knew you were going to have to meet the big bad but-for standard that was going to destroy all our rights? If you knew you was going to have to meet that standard anyway? That's what's being admitted here, is that he knew he was going to have to meet that standard anyway. One more time, fam, before we move on to the next article, and I really am done with this article now, but one more thing before we move on to the next article. ESN admits this arrangement would allow some claims to proceed past the pleading stage that are destined to fail later as a matter of law. Still, the company insists that is what the statute demands. And I get it. Just to be fair to Byron Allen, I get it on some point because it is so hard to prove a but-for standard. I get saying that, yeah, some black people should allow to bring false claims in order to protect the black people who are bringing legitimate claims. All right, I get that, but at the same time, I'm wondering again: is all of this about black rights, or is it about Byron Allen's rights and Byron Allen's bag? Which is what I've been questioning all along. Now let's get into another article, fam. So this is an article from a brother named Mark Harris. He is a lawyer, so I know people like to say, you don't have the data, you don't have the education. So since we want to give credence to education that comes from the system of white supremacy, credentials that come from the system of white supremacy, degrees, since certain people in the ADOS movement want to brag about credentials. This gentleman has credentials. This gentleman is a lawyer. His name is Mark Harris. He's a lawyer in the Ben Crump law firm located in Los Angeles. There's more than one Ben Crump law firm. Now, y'all know when I was making my sleazy merit videos, I obviously don't trust Ben Crump. I really don't trust anyone who works for any of his law firms. However, just because I don't trust someone generally or I don't agree with someone generally doesn't mean I can't admit that they're right. In my last video, obviously I've had a lot of problems and still do have a lot of problems with Antonio Moore and Yvette Carnell and people who follow them. Yet I was still willing to admit and give props to Yvette Carnell and Antonio Moore for exposing Jay Morrison. So just because I disagree with you on most things doesn't mean that you're automatically wrong on everything. Hell, with Trump, I think he's a big-time racist and white supremacist. I still agree with him on a lot of things. I agree with him calling the China virus the China virus. That doesn't mean I agree with him on everything or that I want to throw on a MAGA hat and become a black white supremacist. So just because I disagree with someone, or even if I disagree with them most of the time, or I disagree with them on big issues, doesn't mean I can't acknowledge when they tell the truth. That's called intellectual dishonesty, when you're not able to acknowledge when someone is telling the truth, even when it's coming from someone who you normally don't like or don't agree with. So I don't want people saying, "Oh, well, he worked for Ben Crump. He don't have no credibility because he worked for Ben Crump." Because second of all, not only does the man work for Ben Crump, but he takes the side of the Byron Allen side of the story. He's saying, he's agreeing, as I read this article, and this is one of the articles I'm going to read the entire article. He is saying that the law is changed. But his thing is that the law is changed partly because of Byron Allen. And again, I just want to keep re-emphasizing, fam, just to keep y'all grounded. Remember, officially, technically, by the book, the law wasn't changed. It was only interpreted, which it could have been interpreted either way. Again, remember the Christianity example about denominations. The same verse can be interpreted 6 different ways. It's kind of the same thing with the law. And not just this law, a lot of laws. That's why we have a Supreme Court in the first place. But this gentleman's interpretation is the same as Byron Allen's and many other people's interpretation of this law, which is that because of the Supreme Court's ruling, it is now changed, meaning that their interpretation was that before it was a motivating factor law, standard law, and now it's been changed to a but-for standard law. That's this gentleman's opinion, and you'll see that as I read this article. But just keep in mind that even though he takes the side of Byron Allen, he still partially, not completely, but he still partially blames Byron Allen for this law being changed, in his opinion, which again, we don't really know that it was changed. But if it was, he's partly blaming Byron Allen. So let's go ahead and read this article. This is an article in the LA Sentinel by Mark Harris. And it says, businessman Byron Allen, Comcast, and the Supreme Court all... My bad, fam. Businessman Byron Allen, Comcast, and the Supreme Court all had hands in weakening the strongest anti-discrimination law in the history of the United States, as we are consumed watching coronavirus updates. And again, let me reread that because he's blaming them. So again, he's blaming Byron Allen, Comcast, and the Supreme Court. Businessman Byron Allen, Comcast, and the Supreme Court all had hands in weakening the strongest anti-discrimination law in the history of the United States, as we are consumed watching coronavirus updates. Section 1981 of the United States Congress Civil Rights Act of 1866 banned racial discrimination in making and enforcing contracts and guaranteed African Americans the same rights as white citizens in employment, contracting, and other business agreements. President Andrew Johnson vetoed the legislation twice, but a 2/3 majority in both the Senate and the House overrode his veto and passed the bill into law. Now, a unanimous U.S. Supreme Court decision handed down last week in the case of National Association of African American Media, which is Byron Allen, versus Comcast, severely weakened that 154-year-old statute. Here's the backstory of the case that led to the decision and what it means for African Americans. Allen, the former comedian, actor, and talk show host, starred in the well-known television show Kicking It with Byron Allen, formerly Jammin'. It was broadcast live for over 20 years and is among the longest-running shows in television history. Allen got his start in entertainment as a member of the writing team for J.J. Dynamite Evans, and I'm adding in that Dynamite. Y'all remember J.J. Evans, actor Jimmy Walker's character on the popular 1970s sitcom Good Times. Now, I want y'all to remember that, fam. That's just interesting. That's not really have nothing to do with this case, but it's very interesting, fam. Byron Allen got his start writing for a character who was known as a Sambo. As a matter of fact, Jimmy Walker, the actor who played JJ Dynamite, he is now a big-time Sambo. And part of his excuse for being a Sambo was that a lot of black people used to go in on him because his character on Good Times was a Sambo and a tap-dancing minstrel. That's the opinion of a lot of black people, even back in those days, that J.J. Evans was a minstrel. And because of that, the real-life version of him has become a real-life minstrel and is dating open white supremacists like Ann Coulter. Look it up. Do your own Google research. So I'm saying that that's interesting that the person who was writing those lines that many black people took as a minstrel, the person who was the creative writer behind the minstrel talking points, was Byron Allen. I'm just saying, fam. It's kind of interesting that Byron got his career start, writing lines for a minstrel character. It's very interesting, fam. I'm just saying. In 2019, along with Sinclair Broadcast Group and Diamond Holdings, purchased 21 regional Fox Sports networks from the Disney company. Today, Allen's company is a global media conglomerate that owns 10 cable television networks. I'm going to reread this part, fam, just because I want y'all to remember it. Put it in the back of your mind, because we're going to come back to it in another article. In 2019, Allen, along with Sinclair Broadcast Group, the pro-Trump media organization, the same Trump who members of the leaders of the ADOS movement jumped out the window on people because they claimed that these people were supporting Trump. Yet Byron Allen is running around with these Trump-supporting Sinclair, this suspected white supremacist Trump-supporting Sinclair Broadcasting. That's okay, but somebody sounding like they might support Trump is not. But doing business with Trump supporters is. And the reason why I want y'all to remember that is because I'm going to come back to it later. The 21, him joining up with Sinclair Broadcast Group and buying and helping them to buy 21 regional networks. I want y'all to remember that. So please put that in the back of your mind, because we're going to come back to that subject on a different article. But anyway, let's continue with this article. Again, Allen's company is a global media conglomerate that owns 10 television networks, including Weather Channel, Comedy TV, Justice Central TV, among others. Allen also owns Entertainment Studios Motion Pictures, which produce the motion pictures 47 Meters Down, Chappaquiddick, and Uncaged. In 2015, Allen filed a $20 billion federal lawsuit against Comcast, the cable company, alleging racial discrimination. Allen, along with others, filed the case of NAAOM, which is Allen versus Comcast. In their complaint, Allen and the other plaintiffs contend that Comcast turned down Allen's potential deal to feature 6 of his stations on Comcast. Allen alleges he was denied the deal due to his ethnicity in violation of a portion of 42 U.S.C. Section 1981. Section 1981 is a Reconstruction-era federal statute providing all persons to make the same right enjoyed by white citizens, and to make and enforce contracts, and to sue for the enforcement of those contracts. Comcast has vigorously defended its record on diversity and refuted Allen's claims of discrimination. A key element of Allen's argument centers on Comcast's alleged collusion against his interests with certain African American leaders and organizations during this 2010 purchase of NBC Universal. As part of the NBC Universal deal, Comcast agreed to add 4 new African American owned networks over 8 years. 2 of those networks were owned by Sean Diddy Combs and NBA Hall of Famer Magic Johnson. Allen argued that the organizations that helped broker the deal, the National Urban League, Reverend Al Sharpton's National Action Network, and the NAACP, were essentially bought off by Comcast, which has donated money to them. According to Allen, the agreement provided only token investment in black-owned networks and has been used to justify blocking black entrepreneurs from getting a seat at the multi-billion-dollar cable television ownership table. At the federal trial level, the case was dismissed. Next, the United States Supreme Court Appeals for the Ninth Circuit resurrected Allen's case, holding that the trial court considering the lawsuit had improperly dismissed it. Comcast appealed that decision to the United States Supreme Court. Allen proceeded with his opposition to the Comcast appeal and came before, which means that Allen could have dropped it after Comcast appealed. He could have dropped it, but no, he kept going forward. And Allen proceeded with his opposition to the Comcast appeal, and the case came before the Supreme Court for oral argument in November of 2019. The narrow issue the U.S. Supreme Court considered was not the specifics of Allen's dispute with Comcast, but the standard for proving racial discrimination under 42 U.S.C. Section 1981. The justices seemed to focus on the question of whether a plaintiff like Allen must make the case that racial discrimination was the main factor or just a contributing factor in Comcast's decision to reject his company's deal. Then, this past week, in a unanimous decision, the Supreme Court sided with Comcast and set a new but-for standard. And again, the fact that they're saying that this is new, it's only new because now it's across the board. It's not new in that it could have been ruled before this Supreme Court case that the law was still under the but-for standard. Actually, Byron Allen, remember, when he got his case dismissed 3 times, that's because that court was already using the but-for standard before the Supreme Court. So again, this is all about interpretation. So all of these declarations that the law was just changed, it's not really true. But anyway, let's continue. Then this past week, in a unanimous, but he cost millions, but he couldn't even get one justice to side with him. I'm just saying, but people bragging though. People being arrogant and bragging about how much money a lawyer costs. Then this past week, in a unanimous decision, the U.S. Supreme Court sided with Comcast and set a new but-for standard in cases involving allegations of contractual discrimination under Section 1981. The case was then remanded back to the trial court to determine whether Allen could meet the new standard. Allen will have to prove that but for his ethnicity as an African American, he would have been awarded the contract with Comcast. What does this dispute between Allen and Comcast mean to the African American community? First, the words of the Kenyan proverb, "When elephants fight, it is the grass that suffers," that comes to mind. The fact that this litigation will have long-term implications on the next litigants who allege they were denied a contract, employment, or business opportunity due to racial discrimination is inescapable. Again, what he say? In the words of the Kenyan proverb, when the elephants fight, it is the grass that suffers. So who's the elephants? Comcast and Byron Allen. He's saying that Byron Allen is not on the same level as most black people. Antonio Moore and Yvette Carnell will tell you that. That's why they're always going in on black celebrities and the black decadence veil and all of this. Byron Allen is not on the same level as the condition of most black people. So Byron Allen is one of the elephants because he's after his own bag. And you can disagree, but that's what it looks like to me, and that's what it looks like to other people. When the elephants fight the grass, it is the grass that suffers. Byron Allen is one of the elephants. But let's continue with the article. The U.S. Supreme Court's decision in this case has effectively increased the burden of proof on the next litigant and made it much harder for them to succeed in Section 1981 litigation. One is left to wonder why such powerful members of our community could not have somehow come together to protect the interests of all African Americans. Here, by the insistence of Allen to proceed with this litigation, the African American community runs the risk of becoming trampled grass. Again, here by the insistence of Allen to proceed with this litigation, meaning that this man is saying that had Byron Allen decided not to bring this lawsuit, the law might still be what it is. We might still have a motivating factor standard to be held to if it wasn't for Byron Allen. That's what he's saying. Here, by the insistence of Allen to proceed with this litigation, after he took multiple L's, but he kept appealing and appealing and appealing until he ended up causing the law to be changed. If it was even changed, if that's really how you want to look at it. Here, by the insistence of Allen to proceed with this litigation, the African American community runs the risk of becoming trampled grass when the litigation is finally resolved and the elephants have ceased fighting. Second, ultimately, Allen's group will have their day in court at the trial court level where they will have to prove that they suffered specific discrimination at the hands of Comcast relative to its decision to reject their proposed cable deal. The legal standard will now be higher with a requirement that Allen's group prove that but for being a black-owned enterprise, they would have been awarded the cable deal by Comcast. This will prove a very difficult standard to meet. Third, one must wonder, and as a matter of fact, I'm not going to read this last paragraph, but fam, what he's talking about is The fact that this was ruled unanimously, even the justices, even the judges who were appointed by um, Barack Obama and Bill Clinton, this was unanimous. So even the justices that were appointed by Barack Obama and Bill Clinton, even they ruled against Byron Allen and supposedly took away all black rights according to the ADOS movement. Even the judges who were appointed by Democrats. So again, remember, fam, remember that when people are telling you it's Democrat down ballot, we got to support the Democrats. Because now that the Supreme Court has made its decision, you know what has to be done in order to gain our rights back, since Antonio and Yvette told you that this was so important. Now we have to fight to get the law changed. How do we get the law changed? By senators and congressmen. The people who somebody in the ADOS movement told you to vote down ballot for. Now, why would you vote down ballot for someone who has not promised you that they are going to change the law to over? Because the only way the Supreme Court's ruling can be overridden is if you change the law. That's the only way. That way it's no longer up for interpretation, and you change the law to a motivating factor law. That way the Supreme Court can't decide that it's but for, because they can only interpret the law. And if the law clearly says that it's motivating factor, them putting a but for standard on the law would be illegal. So the only way you can change it, fam, is if you go to get the senators and your Congress people to change the law. Now, somebody's telling you to vote down ballot for people with no promise that they're going to change this crucial law that protects all black rights. Why is that? Yet you should vote down ballot. For what? But I digress. But that's all he read, fam. I didn't want to read that part of the article and make the video longer than it already has to be, because obviously, as I said, fam, prepare for this to be a much longer video. We're already over an hour. But we're getting through it, fam. We only got a few more articles to read and then we'll be done. So, next article. I'm only going to read one paragraph from this article. This is an article from the Associated Press. And it says, Justices toss decision in media mogul Byron Allen's case. One moment, fam. I'm looking for the part of the article. So this is the only paragraph in this article I'm going to read. And again, it's from the Associated Press. Justices toss decision in media mogul Byron Allen's case. Allen's lawyer had said previously he would go forward with the case no matter what the Supreme Court decided Allen needed to show. Again, Allen's lawyer had said previously that he would go forward with the case no matter what the Supreme Court decided he needed to show. Now, certain people told you that this fight was all about the but-for standard, and it was all about our rights and the discrimination level that we have to meet. Yet, even though he's lost the case, he's still proceeding with his lawsuit. Why? I thought the whole fight was about protecting the 1866 law, which you've lost. So why haven't you moved on immediately, or why aren't you saying that you're going to immediately move into activism with politicians to get the law changed? No, you said you're going to proceed with the lawsuit no matter what the Supreme Court decides. Why? Because the bag is of utmost importance. Otherwise, why are you still kind of trying to go after the bag after you've lost the case and you claim that you were in this just to protect our rights? Why are you still suing Comcast and actually honoring the so-called impossible standard? I thought that was the whole point, is that the standard is impossible and you shouldn't have to meet it. Yet you're still trying to meet that standard because you're still trying to get that bag. That's of utmost importance to you, is getting that bag, not protecting black rights. Otherwise, you would drop the lawsuit. Because at this point, you've already lost the case that you claimed, or that your followers and your propagandists, the ADOS movement, is telling us that it was only about protecting our rights. Yet, the pursuit of the bag continues. I'm just saying. But anyway, that's all I want to read from that article, fam. So let's move on to another article. And I'm looking at this article to see if I even want to read anything from it. All right, so I was thinking about reading something from one of the articles, but I've decided not to. I'm not going to read anything from it. So now the next article I want to read is something from a website called The Wrap, and it says Supreme Court Justices quiz Byron Allen's lawyers on legal standards for racial discrimination cases. All right, and it's the paragraph I want to read from this article is the challenge hinges on the court's interpretation of the 1866 Civil Rights Act, which grants non-white citizens the same ability to make and enforce contracts. Previous federal court decisions have varied in how the law is interpreted. Again, previous federal court decisions have varied in how the law is interpreted. Previous federal court decisions have varied in terms of how the law is interpreted. Our previous federal court decisions have varied in how the law is interpreted in terms of the legal standard necessary to bring a discrimination case, which means, again, like I was saying, depending on which court you're going to, you might already have to meet the but-for standard. Depending on which court you go to, you might have already had to meet the but-for standard, but there was also a chance that you would only have to meet the motivating factor standard. But because of Byron Allen's lawsuit and chase of the bag, now it's undisputed that it's the but-for standard. But again, this is why people like myself were saying, I don't know how much this law is changing, because as it's being proven, black people already had to meet the but-for standard. So acting like this was just a phenomenal change in our society is kind of disingenuous, because even before Byron Allen's lawsuit, these articles are telling you that there were black people and other discrimination cases, not just black people, who were already having to meet the but-for standard. So what are you talking about that this is all of a sudden brand new? The only thing that is new is, if anything, now there's no chance of a motivating factor standard, whereas before there was a chance of a motivating factor standard. It just wasn't guaranteed. So one more time, fam, I want to really re-emphasize and drive these points home, because I want this to be understood even at a layman's level. Previous federal courts have varied in how the law is interpreted in terms of the legal standard necessary to bring a discrimination case. And the Supreme Court's ruling in the Allen case could have far-reaching implications regarding how such lawsuits are evaluated going forward. So again, that's from The Wrap. Moving on from that article, fam, and we're almost done, fam. I know we've been going through this. Like I said, prepared for this video to be an hour and a half, hour and 45 minutes. But anyway, let's continue. All right, now I'm going to read this whole article. Or not even this whole article, but most of this article. So this is the one article of all the articles that I'm reading that is biased against Byron Allen and is in favor of Comcast. And it's from Forbes. This is the only article that is taking the side of Comcast. Every other article is agreeing with Byron Allen for the most part, and agreeing with Byron Allen's version of the story for the most part. Even the article from that lawyer that was critiquing him, he still agreed that that the law was changed and our rights have been harmed. And he's a lawyer, because I know people, you don't have the education, you don't have the data. Well, he has the education. All right. So does this guy, because this guy is a lawyer, a Harvard-trained lawyer. The guy who's taking the side of Comcast, he's a Harvard-trained lawyer. So I'm not the lawyer here, but these are lawyers telling you how they feel about this case. A black lawyer told you he partly blames Byron Allen. But anyway, let's go ahead and read this article because, again, fam, we're almost done. But, again, prepared, again, for a long video, even though we're already in the middle of a long video. But anyway, let's continue with this. So, civil rights laws should protect minorities, not frivolous litigators. And it's by a gentleman named Rich Samp. Again, he is a Harvard-trained lawyer. And, okay. All right. So I'm not going to read the whole article, but I'm pretty much going to read the whole article because I'm reading the whole article minus one paragraph, and that's the opening paragraph. Actually, no, I'm going to read the whole. I'm going to read the whole article. I was trying to decide for time's sake whether or not to read the whole article, but I am. So again, from Forbes, authored by Rich Samp, civil rights should protect minorities, not frivolous litigators. Comedian turned Hollywood mogul Byron Allen is bringing his contract dispute with Comcast court to the Supreme Court next week. To hear Allen tell it, Comcast is trying to turn back the civil rights clock and make it harder for minorities to redress racial discrimination. But that's a distortion of the case. Comcast is simply asking the Supreme Court to rule, in line with the vast majority of courts that have addressed the question before the justices, that proving that racial discrimination in contracting requires proving that one has actually suffered an injury. The actual injury requirement allows courts to differentiate between meritorious claims. Meritorious is another word for valid, meaning a claim that actually has basis. Differentiate between meritorious claims and those, such as Allen's, filed simply to force a defendant to settle in order to avoid unwanted publicity. Let me read that sentence one more time. And those, such as Allen's, filed simply to force a defendant to settle in order to avoid unwanted publicity. Allen's media empire includes ESN, which operates 7 cable networks that are available in a limited number of U.S. media markets. Over the past decade, Comcast has declined ESN's request that Comcast carry the network, citing low consumer demand for ESN's programming. Now, let me step in here, fam. If y'all have ever seen Byron Allen's channels, especially comedy TV, they're corny. First of all, they're not black-focused. They're not black-oriented. But even setting that aside, they're corny. They're boring. Some of them that I've seen even come off as low budget. Like that Justice TV thing. And that's just real talk. Y'all can get mad. Y'all can say I'm just a hater. But real talk. Half of Byron Allen's programming is corny. Especially that comedy.tv stuff. It's corny. It's not really that entertaining. At least not to me it is. So I can see, honestly, from an honest perspective, I can see how Comcast would say, hey, it's not because you're black, it's because we don't want these low-rated channels. Nobody really wants to watch them like that. And it would be another thing if it was a niche black channel. I could really get behind it then because it's like, hey, Comcast, you need to make this black channel that's actually black-owned, which BET isn't, available to black people across the nation. But this isn't even focused towards black people. And it's corny. Even at least if it was black focused, even if it was corny, I could still say, I don't think that's an excuse. But when it's a basically another white channel which is owned by a black person and it's whack, I don't know. I can see where Comcast is coming from. Anyway, Allen's media empire includes ESN, which operates 7 cable networks that are available in a limited number of U.S. media markets. Over the past decade, Comcast has declined ESN's request that Comcast carry the networks, citing low consumer demand for ESN's programming. Other cable operators declined similar requests from ESN for similar reasons, citing low consumer demand for ESN's programming. How many people are saying, man, I just got to get Justice TV. I just got to get Comedy TV. Justice.tv. I just got to get Comedy.tv. If the main thing that people might be asking for is the Weather Channel, but even then, who really sits up and watches the Weather Channel all day? Especially when you can just check Google, get on your phone, watch the local news, and get the weather report. Who really sits up and watches the Weather Channel all day in 2020? So even that, do you really believe that there's this high demand for the Weather Channel in 2020? Maybe in 1980, yeah, I would believe that there's a very big demand for the Weather Channel. But in 2020, with Google and smartphones and all these different other ways you can find out the weather, are people really sitting up and watching even the boring-ass Weather Channel for 2 hours straight? Really? I mean, I know there are some people, but really, is there that many people? I don't think so. So, again, it legitimately really could be the real reason why Comcast denied Byron Allen's channels, is because nobody wants to watch them. And if you really look at his channels, that's a believable excuse, not race. So if you believe that it is race, I mean, or not, fine, you want to believe that it's race, but you can't deny that it's also possible to be true that people just don't want to watch this bullshit. People just don't want to watch his channels. They're boring. I'm sorry. But anyway, fam, I'm sorry. I'm going off on too much of a side rant or side tangent. So let's get back to the article. Over the past decade, Comcast has declined ESN's request that Comcast carry the networks, citing low consumer demand for ESN's programming. Other cable operators declined similar requests from ESN for similar reasons. Nobody wants to watch it. In response to refusals to carry its programming, ESN sued Comcast as well as Charter Communications, Time Warner Cable, DirecTV, and AT&T. The suits allege that the defendants violated the Civil Rights Act of 1866, which prohibits racial discrimination in making and enforcing contracts. Several of the defendants settled their claims by agreeing to carry ESN programming, but Comcast chose to fight, and now the case is before the Supreme Court. Meaning that other companies just gave in and said, you know what, we don't want the hassle, we don't want the lawsuit, so we're just going to give in. But Comcast said, no, we're not going to give in. We're big boys. We don't give in. Especially, and they probably did say, especially not to some Negro. And they took their case forward. But this is showing that Byron Allen didn't just target Comcast. He was targeting everybody. So if anybody said to him something he didn't like, which is nobody watches your channel is boring, which could be facts. As far as I'm concerned, it is facts. But I know it's an opinion. Beauty is an eye beholder. Some people might find this stuff entertaining, but I don't. But because they said to him, your shit is boring, nobody wants to watch it, he got mad and said, I'm going to say you racist. Almost as if he thinks he can run around using racism as a weapon against white supremacists. And that is a dangerous game in a system of white supremacy. Yes, when you have legitimate claims, I don't consider that using racism as a weapon. But when you are making false claims of racism, you are using racism as a weapon. And that is and if you remotely understand white supremacy, instead of dating white women, oops, did I say that? My bad, I didn't mean to say that. But if you really understood white supremacy, you would know that it is a very dangerous game to think that you are going to use racism as a weapon to make false claims against white people, when most black people can't even get by with real claims of racism. And you think you're going to run around making false claims and that's going to go over well in a system of white supremacy? Really? You think that's going to result in a positive result for black society? Especially when you are bringing laws into your suspected false claims of racism? There is no direct evidence of racial discrimination here, but Allen alleges that Comcast offered carriage contracts to white-owned networks that had less viewers than ESN's networks. He asserts, and fam, just on a side note, I have never heard anyone specify which networks that were lesser known, which white-owned networks that were lesser known than Byron Allen's that Comcast has taken on. Even the articles that are taking the side of Byron Allen have not told me which of these white-owned networks. They only say that that's what Byron Allen claims. But no one is telling me which networks is Byron Allen talking about that Comcast accepted that have lower ratings than his. I'm just saying, fam. But Allen alleges that Comcast offered carriage contracts to white-owned networks that had less viewers than ESN's networks. He asserts that racial discrimination can be inferred from that allegedly disparate treatment. Comcast denies that it treated white-owned businesses more favorably and that notes that its cable offerings include many minority-owned networks. Among those offerings is the Weather Channel, so Comcast does already broadcast the Weather Channel that Byron Allen owns, which Allen himself purchased for in 2018 for $300 million. The trial court gave Allen 3 chances to submit a complaint that stated an adequate racial discrimination claim. The court found that each complaint insufficient and dismissed the lawsuit. The trial court gave Allen 3 chances to submit a complaint that stated an adequate racial discrimination claim. The court found, and this was a black judge, by the way, fam. The judge that was dismissing Byron Allen's cases, it was a black judge, by the way. I mean, take that how you want, but it was a black judge. The court found each complaint insufficient and dismissed the lawsuit. It ruled that Allen failed to show racial discrimination, not other race-neutral reasons, motivated Comcast's refusal to offer a carriage contract. The trial court's ruling adopted the approach taken by every federal appeals courts in analogous racial discrimination lawsuits. Those courts held that the plaintiff must show that it would have received the desired contract but for the alleged discrimination. Again, let me read that part, fam. The trial court's ruling adopted the approach taken by every federal appeals court in analogous, meaning similar, racial discrimination lawsuits. Those courts held that the plaintiff must show that it would have received the desired contract but for the alleged discrimination. So remember, again, the ADOS panic machine was telling you that we had the motivating factor standard, and all of a sudden, and no black person would have had to meet the but-for standard until evil Comcast came along and decided to challenge Byron Allen's favorable ruling that he only got after he had lost multiple times, and then he finally won an appeal after he lost multiple times. But because big bad Comcast stepped in, now all of a sudden black people were going to have to meet a standard that they never had to meet before. And this was going to equate to the destruction of black rights. But as you've heard in this article and in other articles that I've read, there were already black people who were having to meet the but-for standard before Byron Allen's lawsuit. Because you live in a system of white supremacy, fam. And that's what you always have to keep on the forefront of your mind. If you do not understand white supremacy, everything else you think you understand will only serve to confuse you. Shout out to Neely Fuller. Allen appealed, and the U.S. Court of Appeals for the Ninth Circuit reinstated his case. It ruled that under the federal law governing contract discrimination, it was enough to allege that race was a factor in the decision not to sign a contract, even if no contract would have been made if race had played no role. So again, Byron Allen is trying to make it such a low standard that even if he still would have been denied the contract as if he was white, he still can bring a lawsuit. So even if the case basically wasn't about race, this guy, now, okay, you can disagree with him, but this guy is saying that even if the case was not about race, Byron is trying to make it so that he can still bring the lawsuit, claiming that it's about race. Even if no contract would have been made if race played no role. The Supreme Court last June agreed to review Allen's case, as it often does when 2 or more federal appeals courts disagree about how to interpret a federal law. The standard of proof applied by a trial court makes a difference in discrimination claims of this sort. Allen's claim is thin at best, and sorry, I got distracted. Um, my bad, fam. My dog was walking around doing something weird. But anyway, the standard of proof applied by a trial court makes a difference in discrimination claims of this sort. Allen's claim is thin at best. Nothing in his complaint suggests that Comcast considered Allen's race when it declined to offer his networks a carriage contract. But if the Supreme Court adopts the lenient standard Allen proposes, that a plaintiff need only allege that race was a factor, meaning that as long as this guy is saying that what other articles weren't telling you, that as long as you claim that race was a factor, that's enough to meet motivating factor standard, meaning that you don't have to prove that it was a factor, you just have to claim that it was a factor. The plaintiff need only allege that race was a factor in the contracting decision. It will become extremely difficult for a defendant to win early dismissal of even the most frivolous claims. And once a plaintiff survives a motion to dismiss on pleadings, the high cost of litigation, including the cost of responding to endless depositions and document requests, which is what Byron Allen was fighting to be able to do. He was saying, hey, I shouldn't have to fully prove my case until I can make Comcast submit all these documents and come in and testify for depositions, because that's what a deposition is. It's a testimony. And fam, I don't know if y'all can hear it, but there's like a train in the background. It's a little bit distracting, at least to me, but I'm going to try to talk through it. But if y'all can hear it, my bad, fam. My bad for the distraction. I told y'all I live by a train, but hopefully y'all can't even hear it, and I'm just talking. But again, the high cost of litigation, including the cost of responding to endless depositions and document requests, will virtually force the defendant to settle the lawsuit without regards to its merits, which basically means that Byron Allen was planning on being able to take this 1866 law and say, hey, you're a big corporation, you don't want all these problems, I got big money, so I'm going to waste your time making you testify, subpoenaing documents, making you spend a lot of legal money defending yourself against me, and giving you bad publicity because I'm calling you racist. And every other company, DirecTV, AT&T, they all folded. They say, you know what? We give up. You got it. But Comcast said, no, we're not going to be bullied. At least according to this guy's version of the story. Which he's telling you facts that other people are not telling you, that Byron Allen, even if you don't agree with this gentleman's version of the story that's writing this article, you can't deny the facts that Byron Allen has a history of suing multiple cable carriers for not carrying his channels. Multiple cable carriers. And it looks like he's using it as a weapon. And again, and will force the defendant to settle the lawsuit without regards to its merits. That may well be what Allen is counting on. But Congress adopted the civil rights laws to eliminate racial discrimination in the making of context, not as a litigation tool that unhappy plaintiffs can use to browbeat others into making unwanted deals. Byron Allen should not be permitted to besmirch Comcast's civil rights record for the purpose of expanding his own business. All right, fam. And now that I read that, I'm going to read an article from the New York Times, and I'm not going to read the whole article. The whole article is another article that takes the side of Byron Allen, but I just want to read one part of it, and it's the part of another black business channel owner saying that Comcast did fair business with him, which again further points to the fact that Byron Allen's lawsuit might not even be legitimate. It might not even really be about race. But anyway, fam, so this is from the New York Times. This is, and hold on, fam, let me adjust something real quick. 1 second. My apologies for the distraction, fam. And we're almost done, and I guess this is going to be a 2-hour video, but it is what it is. I got to get through this, and I got to get through all these facts. So anyway, this is an article from the New York Times. It says, Byron Allen spares no one in accusing Comcast of racial bias. and it's from the New York Times. And it's from a black man named John Eligon. All right. And again, I'm not reading this whole article. Most of this article agrees with Byron Allen's side of the story, but I just want to read one part of this article that points out how another black channel owner is claiming that Comcast did fair business with him. Just to give you a perspective on the possibility that this might not be about race the way Byron Allen's side of the story is claiming that it is. One black network owner, Mr Bollanga, praised the company, saying that it had come through with a minimum subscriber guarantee last year when it started distributing his network, Afro. Comcast offers the channel in its 13 largest markets, Mr. Bollanga said, adding that more than 80% of Afro's 11 million subscribers are through Comcast. The millions of dollars his company collects from Comcast and subscriber fees has allowed it to expand, including the construction of a 35,000 square foot studio in Orlando, he said. Mr. Bollanga said that he had been in discussions with Comcast since 2007, and the operator had rejected him in the past. He gathered data to make his case to Comcast executives that they should carry his channel. Rejection should not always equate to racism, Mr. Bollanga said. Byron Allen is putting civil rights protections on the line. So that's now a second black man that's saying that it's Byron Allen that put the civil rights protections in jeopardy because of his own personal dispute with Comcast. Rejection should not always equate to racism, Mr. Bollanga said. Byron Allen is putting civil rights protections on the line. That's all I wanted to read from the New York Times article. And now, fam, we're almost done. We only got 2 more articles. We're almost done. Bear with me. I know it's been such a long video, but we're almost done. All right, now this article is from a website called The American Prospect. It's written by a white man named Matt Stoller. And this is another gentleman who was pretty much taking the side of Byron Allen. If you read this whole article, he's saying that it's changing our rights. He's saying that black people experience racism. He's taking the side of Byron Allen. But there's parts in this article that I want to read that show that even he's acknowledging that this might be about Byron Allen more than it's about black people. And again, this is a white man. And again, read the article for yourself. This is not some biased article. The only article I read was the article I just read from Forbes that was biased against Byron Allen. Every other article is in favor of him. But anyway, again, it's from the website The American Prospect. It's written by a white man named Matt Stoller, and our name of the article is Remote Control. A civil rights lawsuit highlights how Comcast monopoly crushes media diversity. That's the title of his article. All right. And so, again, I'm not reading the whole article, just parts of it. So I'm starting from the paragraph that says, Allen is respected for his drive and hustle. The Byron I know is a salesman. He's always got a pitch, combined with a visionary who believes in the need for more diversity, said Robert Johnson, the legendary billionaire and founder of Black Entertainment Television. When Allen branched into film in 2015, music business icon Quincy Jones said, I am very proud of Byron and I hope he adopts me. Last year, Allen bought the Weather Channel from the Blackstone Group, Bain Capital, and Comcast, and he has a $500 million credit line for more acquisitions. And yet his colleagues mix this respect with a certain distance, a fear of his raw ambition. He made his money, as one person involved in the Comcast dispute told me, by gaming the white boy system. His racial discrimination lawsuit against Comcast is, as he says, about economic inclusion, but it's hard to avoid the conclusion that in some ways it's about economic inclusion for Byron Allen himself. Let me read that again. His racial discrimination against Comcast is, he says, about economic inclusion, but it's hard to avoid the conclusion that in some ways it's about economic inclusion for Byron Allen himself. And there goes that damn train again, fam. 1 minute. Let's just let that sink in. I'm going to try to talk through the sound because I'm not even sure if y'all can hear the train, but I can, and it's distracting me because it's loud as hell. That damn horn on the train is loud. But again, in April 2019, for instance, or no, let me back up. It's hard to avoid the conclusion that in some ways it's about economic inclusion for Byron Allen himself. This is a guy who's writing an article taking the side of Byron Allen. In April 2019, for instance, black celebrities Magic Johnson, LL Cool J, and Serena Williams tried to buy 21 networks Disney had to divest as a condition of its merger with Fox. Allen, by contrast, joined the rightward tilting Sinclair Broadcast Group as a minority investor, and Sinclair was able to buy Disney's assets. So, and I want y'all to read, I'm going to put the links, there's a link from the final call, and you can do your own research. Basically, what black people have been asking our black celebrities and entertainers to do for so long, Serena Williams, Magic Johnson, LL Cool J, and Ice Cube actually also was involved, from what I understand. Even though this article doesn't mention Ice Cube. From what I understand, Ice Cube was also involved. Were going to pool their money to buy regional networks because what happened was Disney bought Fox. However, in order to avoid being considered a monopoly, Disney had to sell certain Fox properties. And one of those Fox properties were 21 regional sports networks. Now, the regional sports networks, these are the things that broadcast things like your NBA, your local NBA games. Those of you who watch the NBA, you know that a lot of times, unless your team is on like TNT, you can only watch the Hawks on your local channel. Like if you live in Atlanta, you can only watch the Hawks on your local channel. If you live in LA, you can only watch the Lakers on your local channel. Like if the Lakers are on NBA TV and you live in LA, you can't watch them on NBA TV. You have to watch them on the local channel. That's what the regional sports networks are. That's big money. Not only that, a lot of the local college games and things like that. That would have given, and even in the final call article, it talks about how had these black people, these black celebrities and entertainers, had they pooled their money to buy a black-owned package of channels like that, they would have had enough resources to then develop yet another channel or build in more content into the channels that they already bought, original programming, and begin to grow a black-owned media conglomerate. And it's what we ask for when we watch sports. We talk about, why don't the players pool their money and buy their own league? Now, it's more complicated than that, so I kind of understand why players don't just try to pool their money and buy and make their own league. But it's that concept that black people have been asking for so long. Magic Johnson, Serena Williams, LL Cool J, they were making that dream a reality. Yet Byron Allen, instead of joining, he could have took either side. Instead of joining with the other black people to basically do the same thing that he's crying about now. And those regional sports networks, these channels, these companies have no choice but to carry those networks. Because people are going to be, unlike Byron Allen's boring comedy TV and weather channel, cable companies have to carry these regional sports networks. Because if they don't, they're not going to have things like local NBA games, which is going to be a big problem for a lot of subscribers. Local college games. Those things are in high demand. Local sports, regional sports. Those things are in high demand, no matter where you live in the country. Yet Byron Allen still chose to side with the Trump supporting, the same people who the ADUS movement jumped out the window on foundational black Americans for over Trump, and the feeling that you might slightly be supporting Trump or agreeing with Trump on anything. You jumping out the window, overreacting. But Byron Allen chose to side with Trump supporting suspected white supremacists and undermine a historical black owned media deal by siding with the Trump supporting white supremacists. And this article is telling you that. And this is an article that is defending him. That's why he said, before he told you that, he's saying it's questionable whether or not Byron Allen is really in this for black people or himself. Because when he had a chance to join up for black ownership and truly represent black ownership in a meaningful way, he turned it down and sided with Trump supporting white supremacists. But as soon as he doesn't get his way, all of a sudden racism is a big deal. But when you had a chance to join up with black ownership, you declined that idea. But we supposed to believe that Byron Allen, with his white wife, is the biggest racial justice crusader. And those of you who came for interracial dating, you don't understand white supremacy. I'm sorry, but you don't. Again, I want to reiterate that. But it's hard to avoid the conclusion that in some ways it's about economic inclusion for Byron Allen himself. In April 2019, for instance, black celebrities Magic Johnson, LL Cool J, and Serena Williams tried to buy 21 networks Disney had to divest as a condition of its merger with Fox. Allen, by contrast, joined the rightward tilting Sinclair Broadcast Group as a minority investor. Allen's company got several of the stations. So Byron Allen prioritized his own personal gain of some of those stations over the collective gain of black people. But you want me to believe that Byron Allen is all about the collective of black people and not about himself. But Allen's basic argument, whether put it forward in good faith or not, is right. And that's this guy's opinion. And again, like I said, he's agreeing with Byron Allen. So that's not me saying it. That's the article writer saying that. But Allen's basic argument, now remember, he's putting in that caveat, whether it's in good faith or not, which meaning he's putting in the seeds of doubt that this lawsuit might not have been in good faith. But he's saying that Byron Allen was still right in his opinion. But let me read another part of this article, and then I'll be done. And we're almost there, fam. We're almost at the finish line. And this is a long article, so I really got to scroll through this one to find the part that I'm looking for. All right. In some sense, Comcast is acting like a standard, unregulated monopoly without racial animus. Earlier this year, The Hollywood Reporter revealed that it was removing 17 Starz channels from its lineup, channels owned by a non-black company, Lionsgate, due to a nasty dispute over fees. Again, Starz is owned by white people, yet they had a dispute with Comcast also. Due to a nasty dispute over fees. Comcast will replace them with a rival, Epix. This is the heart of 50 Cent's fight with Comcast, since his show Power is carried by Starz. And again, this is not about 50 Cent and Power, so don't say, oh, they being racist to 50 Cent too. Please don't be stupid. This is not about Starz. This is about the fees that Comcast charges. This is not about Power. This is about the fees that Comcast charges to Starz, which is owned by white people. 50 Cent has nothing to do with the negotiations other than he's constantly on Twitter because he knows that Starz not being on Comcast will severely hurt its ratings. But he is not directly involved in the negotiations with Comcast at all. So again, and this is a guy who was siding with Byron Allen. In some sense, Comcast is acting like a standard, unregulated monopoly without racial animus. Earlier this year, The Hollywood Reporter revealed that it was removing 17 Starz channels from its lineup, channels owned by a non-black company, Lionsgate, due to a nasty dispute over fees. Comcast will replace them with a rival, Epix. This is at the heart of 50 Cent's fight with Comcast, since his show power is carried by Stars. And one second, fam. I'm still. Um, all right. So, and this is another part of the article. It's certainly possible that Comcast executives are openly racist. After buying NBC, Comcast switched the chief diversity officer from a black woman to its main political fixer, chief of lobbying David Cohen. But most of the people I spoke with in the industry believe that Comcast is simply destroying independent programmers, not solely targeting black programmers. The company has squeezed out Fuse, BEIN Sports, or Bean Sports, however you pronounce that, the tennis channel, and Altitude TV, and is in a fight with the owner of the Los Angeles Rams, who is married to an heir of the Walmart fortune. Comcast has even fought with Michael Bloomberg, who's a billionaire, over carriage of his corporation's business channel. So as you can see, this article is saying that Byron Allen is fighting with, not Byron Allen, Comcast is fighting with people left and right. Now, Byron Allen is fighting with people left and right, too. That's why he's bringing lawsuits left and right against multiple cable companies, not just Comcast. And half of the other cable companies that are carrying his channels, they're carrying it only because they didn't want the lawsuit hassle from him. But they basically said the same thing Comcast is. But even if Comcast is screwing Byron Allen, this article, which is siding with Byron Allen, is telling you that it might not be about race. Even if they are screwing him, it might just be about them being a monopoly, because they're doing this to a lot of white people. They're doing this to white billionaires, let alone black ones. That's what this article is telling you. Comcast has even fought with Michael Bloomberg over carriage for his corporation's business channel. So this just sounds like cutthroat business, not necessarily racism. Yet Byron Allen wanted to tell you that it was, and have his ADOS minions tell you that it was all about racism, while he won't even acknowledge the ADOS movement. Comcast only wants to do business with large integrated systems that produce must-have content like Disney, Viacom, CBS, and AT&T Time Warner, with streaming options, Netflix, and Amazon in the wings. New technology such as high-speed 5G mobile technology could fragment the market, providing opportunity for new streaming options, at least temporarily. 50 Cent is aggressively promoting Star's streaming app, but today pay TV remains the dominant distribution and investment system, sustained in high-quality narrative video content, and there are no limits to consolidating what comes next. And again, that's from Matt Stoller, and I just got one last article to read, fam, and we are done. And we're basically done at 2 hours, but again, my bad, fam, for the long video. So I wanted it to be like an hour and 45 minutes, but obviously it's 2 hours, but we're almost done. So now this is an article that's unrelated to everything else I've just read, but it just shows that Byron Allen has a habit for lawsuits, because shortly after this case, after he lost his Supreme Court case, guess what? Byron Allen is suing somebody else. Media mogul Byron Allen sues Nielsen for breach of contract. Byron Allen with his media company filed suit Friday against the Nielsen company. Entertainment Studios, parent company of the Griot, and I'm reading this from the Griot, so this is an article from the Griot, the media, the news, quote-unquote, website that Byron Allen owns. Parent company of the Griot, so Entertainment Studios, parent company of the Griot. The media group founded and owned by the comedian turned businessman, filed the lawsuit in an Illinois court, accusing the ratings firm of predatory pricing, according to the Hollywood Reporter. Now, for those of you guys who don't know, Nielsen, and I'm not a big communications expert either, but from what I know, Nielsen is the company that determines ratings, are I don't know, somehow they charge fees to give ratings or whatever, but they're basically the ones who control the ratings of channels and TV shows. That's a layman's term. And he's suing them. The people who control the ratings of networks and TV shows. And apparently there's some fee involved with dealing with them. I didn't know that, but he's bringing a lawsuit against them. Filed the lawsuit in an Illinois court, accusing the ratings firm of predatory pricing, as reported by the Hollywood Reporter. Allen's company, which owns the Weather Channel, made the lawsuit under CF Entertainment Incorporated, the original name of his media and entertainment company. CF Entertainment in 2017 signed a contract with Nielsen agreeing to pay $41,667 a month in exchange for ratings numbers for its current and future cable networks. So I guess they keep the ratings and then they sell you what your ratings are and you have to pay a price so that you can know what your ratings are, which I didn't know that they charge for that, but apparently they do. In exchange for ratings numbers for its current and future cable networks. After CF Entertainment acquired the Weather Channel in 2018, Nielsen required an amendment to the contract and upped the price to more than over $475,000 a month. Allen argues the change effectively broke the contract. So once again, fam, I'm not going to read this whole article, but once again, fam, now he's not claiming racism in this case, but again, once again, fam, anytime a business deal doesn't go the way Byron Allen likes, he sues. We're seeing a pattern of that, which further points to the fact that this lawsuit may not have been about race. This may have just been about Byron Allen's bag, because clearly he has a habit of running around with lawsuits anytime things don't go his way. He's already suing somebody else. You just had this big, long, drawn-out court case, 4 or 5 year long dispute with Comcast, and you don't get lawsuit fatigue, Byron Allen. I wouldn't either if that's the way I make my money, and that's the way I force people to do business with me, even when they don't want to. But again, it brings in the question whether or not Byron Allen's lawsuit against Comcast was really all about him being the hero of black people and the crusader for black rights, if it was really about that, or if it was really about maintaining his own bag. And the fact that he's constantly involved in lawsuits, and he's involved in yet another lawsuit, even as we speak, it just makes you think, fam. I want everybody to draw their own conclusions from this video. You can agree with what I said, disagree, but I've brought a lot of my opinion, but I've also brought a lot of facts that weren't being told to you by the ADUNS movement. They weren't telling you that this law was about interpretation, not about what it actually said. They weren't telling you that there were already black people who were having to meet the but-for standard, even before Byron Allen ever thought about suing Comcast. They weren't telling you all the facts. They weren't telling you the fact that Byron Allen has a history of bringing lawsuits. They didn't tell you the fact that Byron Allen said that even if he lost the Supreme Court case, he was still going to be suing Comcast. They didn't tell you all that. They just told you it's all about black rights. It's all about Byron Allen being the hero of black people. They told you it's silly and childish to call out Byron Allen for doing business with Sinclair Broadcast Group, because when you a businessman on Byron Allen's level, you have no choice but to do business with white people. Yeah, my apologies for the cough. Y'all don't understand. You can't do business with nobody but white people. Well, Byron Allen had a chance to do business with other black people, and he still chose to take the side of white people. Trump supporting white people on top of everything. But they told you that Byron Allen joined up with Sinclair because there was nobody else to join up with, which turns out to be a bold-faced lie. That's what they told you. So I wanted y'all to get the truth and the facts behind the Byron Allen case. Take it how you want, but I've given y'all the facts that other people have left out. But anyway, fam, that's another video. Like, share, subscribe, and peace.